Ben Bullock from Together SC, and I want to welcome you this morning. Today's session is incorporating DEIA in legal and governance documents. I'm excited to introduce to y'all Elizabeth Riddle and Clay Grayson from Grayson Law Firm. They've been partners with us at Together SC for longer than I've been here, and that's nearing on 10 years now. So I'll turn it over to Clay and Elizabeth to introduce themselves. Good morning.
Good morning. Thank you, Ben. Thank you all for joining us for this quick AM. Maybe this should be like a coffee talk. I have been involved with Together SC for I think now over 15 years, and I just love this organization. I'm a former board member and have stuck around doing speaking and volunteering and occasionally some pro bono legal services. For me, my organization, I know many of y'all, but I see a few new faces. We are a full service business law firm dedicated to nonprofit organizations. I was kind of going over some of our statistics before the call. We now currently represent over 400 nonprofits across the country, actually in about 16 states. We were about a year ago helping, if you added up all the endowments we work with, about $12 billion in endowed assets. Now that's probably 9 or 10 billion, but hopefully that'll come back. Right in this state, we pretty much cover the entire state. We're definitely in the Southeast regionally, but for us, there's not a better organization in South Carolina to partner with than Together SC. This scratches our itch to get out there and provide this kind of training. And I just enjoy the time that I can kind of meet with our people, so to speak. So what we decided here, when I was talking to Madeline last year about how my firm can support or help support Together SC, one of the things that I wanted to do was this series. And I wanted to do real quick, topical information. Madeline wanted us to do checklists, legal checklists, which I find to be fairly boring, but I understand the need operationally for it. So we compromised in the idea that maybe we could do 3 30-minute sessions where we're really focusing on a subject matter or a topic, and then undercover kind of subliminally putting that checklist information of documents or things to think about. We're not going to go really into any depth here. We're going to cover just bigger, higher level information, but obviously we can follow up with you after the call or whenever if you want to dig in further. Our first presentation today is on DEIA in legal and governing documents. I'll talk to you a little bit about that more in a second, but I also wanted to pitch the next 2 sessions because hopefully y'all will enjoy this one so much you'll come back. On September 21st, we're going to do a topic on donor confidentiality. The idea for this one came out of an all-day session we did with AFP in Columbia. And it was interesting, whenever we started talking about confidentiality in any setting, everybody's ears pricked up. And we realized, hey, that would be a good little discrete topic in and of itself. So when we talk about donor confidentiality, we're going to do things like going over gift agreements, going over stewardship with the donor. What do you tell them about the information you collect? We're going to get into legal areas like FOIA, Freedom of Information Act, how confidentiality creates a fiduciary standard in a planned gift. We're going to talk about how you retain that data. We'll talk a little bit about the big blackball data breach from 2 years ago, and we'll kind of get into security policies, IT policies, document retention policies. So hopefully you'll get a lot of good legal information, but really under that idea of donor confidentiality and stewardship. And then the final one we're going to do this year is on November the 2nd. And we're going to go over a topic that I've spoken about a lot recently, and one that I'm really excited about. And that is this tremendous generational wealth transfer we're currently experiencing and are going to experience, for the next 15 to 20 years. People are predicting, I read an article that there's going to be about $9 trillion moving through charitable gifts over the next 20 years into the nonprofit sector. And that's a tremendous amount of funding. What folks don't realize is that you're projecting that 80% of that $7.2 trillion are literally going to be done through primarily through planned gifts, through wills, through charitable trusts, those kind of gift vehicles. And so I want to talk to you, we'll talk to you about how do you capitalize on those kind of gifts? How do you position your nonprofit to really take advantage of that trend in the market? And a lot of that's going to be talking about endowments, endowment planning. Is your organization mature enough to have an endowment? If you have an endowment in place, what do you need to have there? Do you have an investment policy statement, spending policy? So those are kind of our checklist items that we're going to go through, but in the context of that wealth transfer. So I allotted 5 minutes of my time, so I can primarily give this over to Elizabeth Riddle, who's joined us. So Elizabeth is an employment lawyer that's worked with me for about 8 years now. She's practiced law a lot longer than that. She actually did a stint as well in the solicitor's office, which I think makes her a really effective employment lawyer. She's working with me as long as she has. She's very steeped in nonprofits. She understands the role of the board versus the role of the CEO and the staff. She imbues that in all of her work, her employment agreements, her handbooks. And so I think you're going to enjoy her session today. The idea behind this one, DEIA in the legal and governance document kind of perspective, came out. I was at a board, I'm on a board that I served. Sean Edwards, who I think is a Together SC current director, did a 2-part session. We did it over 2 board meetings where we went through a lot of DEI training, and it was incredible. It was a great experience for me. She started off defining what those terms meant for the board, allowing the board to have that space to really talk freely. And I had all these kind of light bulb moments that went off, one of which was, hey, maybe our documents aren't as open to the world. Maybe there's language of exclusion there. We didn't mean that. And so we went through a process of going through, we were already in the process of updating our template bank of documents. And we started going through and thinking about them from a DEI perspective. And that was quite an experience. I will say most of the work got influenced on the employment side, hence Elizabeth is taking the lead on this session. But it was this kind of strange awakening moment where we could see maybe our documents could improve too. And something that's so subtle and foundational there, you go through that organizational learning experience with someone like Dr. Edwards, and then you take that and you translate that into institutional knowledge. And that's where your bylaws, where your policies are there. And so this is our attempt to kind of tell you kind of our in real time processing of DEIA in this context. What are legal action items that actually translate into documents that translate into that saved institutional knowledge for future board generations? This is kind of our thoughts and experience that I wanted to share with you, and Elizabeth wanted to share with you. A couple little quick rules of the road. We'll take questions under the chat. I'm going to be monitoring that. And so if you want to throw them at us as we go, I'll try not to interrupt Elizabeth's flow too much, but we'll stop and pause and have time to do those questions. We're going to try to preserve maybe 5 minutes at the end for Q&A. If there's a lot of discussion, we're happy to stay on as long as you'd like. But without further ado, I'm going to turn it over to Elizabeth Riddle for incorporating DEIA in your legal and governance documents. Thank you.
Thank you, Clay, and good morning to you all. We are talking about DEIA this morning. And I'm going to share my screen. Will you let me know if everybody can see that?
Yes, we can.
Great. So the first question you may be thinking is, what is DEIA? I'm sure many of you have already come across this term, but it stands for diversity, equity, inclusion, and accessibility. And so let's talk about the arc of history and how we got to where we are today. The concept of equity and inclusion really started in earnest back in 1964 with the Civil Rights Act. And there's 2 parts to that act that may apply to nonprofits. The first one is Title VI, and this applies to any program or activity receiving federal financial assistance. And it prohibits discrimination on the basis of race, color, or national origin. The second section, Title VII, is a little bit broader. It's going to apply to private and public employers. And it not only applies to discrimination based on race, color, and national origin, it also includes religion and sex. And it's generally going to apply to those private employers with at least 15 or more employees. And what Title VII does is it prohibits discrimination in all of your employment decisions. So hiring, classifying, promoting, demoting, firing, pay, and employment conditions. 3 years later, we have the Age Discrimination and Employment Act. This prohibits discrimination against people aged 40 or older. And if you're like me, I know what you're thinking, 40 is not that old. And I can say that because I'm in that category, but those are the people protected under that law. And it covers private employers with at least 20 employees. 5 years later, you're going to have Title IX of the Education Act amendments. So we are actually in the 50th anniversary of this law. And this law prohibits discrimination on the basis of sex, and it applies to any education program or activity receiving federal financial assistance. So you see this come up with college and university athletic programs a lot. And you've probably seen that in the news, even in our own state. With Clemson University, I know they've been trying to get equity between their athletic programs. I actually saw an interesting article in the paper just a few days ago about a lawsuit between the federal government and President Biden. He issued an executive order that is intended to protect transgender individuals being able to play on the team that correlates to the gender of their choosing. But there's several states that have sued, one of them being South Carolina. And in May, South Carolina passed a law requiring transgender students to play on the team that coordinates with the gender of their birth. So that has not been settled. There was a recent Tennessee court that issued a stay on that executive order. So it'll be interesting to see how that turns out. We don't have another major law until 1990, and this is the Americans with Disabilities Act. And this has two sections that could apply to nonprofits as well. The first is Title I. This prohibits discrimination on the basis of disability in the workplace. And it's generally going to apply to private employers with 15 or more employees. And not only does it prohibit discrimination, but it goes further and requires employers to provide reasonable accommodations unless they would pose an undue burden on the employer. So Title I applies both to applicants for employment and to employees. And then there's Title III. This applies to places of public accommodation. Those are privately operated facilities affecting commerce and operating in certain categories. And in the nonprofit world, that could include concert halls, auditoriums, stores, healthcare providers, libraries, parks, places of recreation, food shelters, food banks, other social service centers. Title III prohibits discrimination in the full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodations. So this is the law that requires buildings to meet certain standards that make them accessible to people with disabilities. And the Department of Justice is the government entity that enforces that section of the law. And their position is that websites are actually places of public accommodation, even if the underlying organization is not a place of public accommodation. So you have to make sure your website is accessible. So current trends, LGBTQ. In 2020, the United States Supreme Court issued the opinion of Bostick versus Clayton County. And what this opinion says is that Title VII extends to protect against discrimination based on sexual orientation and gender identity. Before this case, that topic it was really unsettled across the nation. You had different areas of the nation applying different rules. And most of the nation was ruling that sexual orientation and gender identity did not fall under the protections of Title VII. Well, that became very clear in 2020 that those two areas are protected under Title VII. So it'll be interesting to see if our current Supreme Court continues that opinion, but for right now, that's the law. The EEOC puts out a lot of enforcement and litigation data, and for the most recent year, 2021, that they have out on their website, the most claims that were filed with the EEOC were retaliation claims. And they broke it down, retaliation under all the discrimination statutes and retaliation under Title VII only. And Title VII was clearly the most, the charges were filed under Title VII for retaliation the most. And so what that tells you is that most people alleging retaliation are alleging it based on race, color, sex, religion, or national origin. And that may be because retaliation claims are a little bit easier to prove. You don't have to prove the underlying discrimination with those types of claims. You only have to prove an employee complained of discrimination and then something bad happened from the employer, and it was because of that complaint. So I speculate that might be why there are so many more retaliation claims. But the third highest amount of claims were disability claims. The fourth were race claims, and the fifth were sex claims. The statistics in South Carolina were a little bit different in that South Carolina had more race charges than disability. We have noticed in our practice an increase in claims against nonprofits. And those are claims having to do with the physical accessibility of the facilities and also having to do with the websites, whether those are accessible to the visually impaired. And so we see this come up with, the building structure, whether people can get into the building, whether they can move around the building, the bathrooms, in gardens, and walking paths, making sure that those are accessible. And then also, as I said, with the websites. So in the year 2020 and beyond, we've now had the hashtag #MeToo movement. We've had the protests spawned by the tragic death of George Floyd and others. And we've had the Supreme Court case of Boston. So all of these issues are having impacts on nonprofits in their workplaces. So what can your organization do to respond to the impacts of the current social movements? Inclusivity starts at the top. So look at your bylaws and your policies. How inclusive is the language? And what we're talking about there is just climatizing gender references. And it's really fairly easy. All you need to do is take he and she and his or her and change it so that you refer back to the subject matter, person or individual. So for example, this is a sentence from one of our conflict of interest policies. And the original sentence reads, each director shall promptly disclose any financial interest of which he or she has in any proposed transaction prior to the start of any negotiation. All you do is you change that sentence to say, each director shall promptly disclose any financial interest of which the director has in any proposed transaction prior to the start of any negotiation. Alternatively, you can list out gender neutral pronouns. There are a lot of pronouns out there that are being used. Z is one that I've seen, ZE, being used a good bit. And of course, they and them is being used a lot. And so some organizations might prefer when they refer to someone to say he/she/the or he/she/they. So the sentence I just gave would read, each director shall promptly disclose any financial interest of which he, she, they has in any proposed transaction prior to the start of any negotiations. I tend to prefer the first option just because it's a little bit easier to read, but either way is better than leaving it as just he and she if inclusivity is your goal.
I see we got a question from Ben in the chat asking, is the singular they okay in legal documents? And I think it is. It's funny from a drafting perspective, we're trained to always draft in the singular, not the plural, because plural can convey ambiguity. So I think you can do it. I would defer to the setups that Elizabeth mentioned. Myself, I'm at a place now where I think it's appropriate to have no gender references, to keep it as neutral as possible, speak about the individual, speak about the person. You know, this is a rapidly changing area. You know, we're in a very dynamic time, and I think if you're gonna go the distance, the longest route is you just eliminate gender entirely. It's funny, when I first started out practicing, I'd see bylaws say his, and then I went through that process of his or her, his and her, that kind of thing. And now we're going completely full circle and saying, let's just get rid of gender entirely if you can do it. And that's my preference. I don't want to steal your thunder, Elizabeth, but the chairman chair is a funny story that I have too. So recently we were going through this exercise with a nonprofit, and because they were, you know, and let's put this in context. When we look at bylaws, we're talking about revamping them every 5 years. That's what we tell people, every 3-5 years, just like you would with a will. Go back and look at it and, you know, incorporate this kind of topic in those other set of changes as well. Now, of course, you can grab and do it right now, but I would think about it in that cadence. And it was interesting. I was talking with this elderly woman who I said, hey, we're switching from chairman to chair. Are you interested in this? And she got real quiet on me and then said, I am not a piece of furniture. And I laughed at that because I wasn't really thinking about her perspective, you know, and in DEIA context, really everybody's perspective counts. I mean, if you're going to have this kind of conversation, really get to a good place culturally and dynamically in terms of your decision making and your group discussions, but it never occurred to me that kind of perspective. So we left it chairman for the time being, recognizing the board, you know, they'll get another bite of the apple. If they want to go to chair, they can do that in the future. But to me, it's an interesting example because it shows a different person's perspective on a word like that. And I don't know that there's a right or wrong answer. I think the right answer is to have this conversation, but I'll stop. Elizabeth, back to you. I'm sorry, I don't mean to steal your thunder.
No worries. You know, another way to deal with it in legal documents is oftentimes we have defined terms. And so, you know, even before all of the gender pronoun stuff started coming up in the news, we were just referring to employees as employee in our employment agreements. So that's another easy way to avoid that issue. Another thing that boards can do in this area is to have an officer responsible for diversity awareness, or you can have a committee. This is diversity, inclusion, equity. Those are very big topics. They can encompass a lot of different things. And so by making it the responsibility of one officer or one committee for your board, there's two things that you can accomplish. Number one, you may be more likely to affect change because there'll be some accountability there. But number two, it also allows you to have that person or committee do the deep dive, and then they can focus down on what your organization really wants to have the conversation be about.
I would offer too that this is a good topic area for either a nominating committee, or now the trend that we're seeing now is a preference for governance committees. So a governance committee would do a nominations, but as well as look at bylaws and documents. This kind of diversity conversation or thought fits well with that type of committee. So as you're looking at your bylaws, you might consider having a home for it there.
I'll just mention in the for-profit world, I noticed there's a national trend in states enacting laws that require a certain diversity of the board makeup, or either require disclosure of the diversity of the board makeup. And I just mentioned that because I think it's significant that investors are driving those laws. So what can you do with your board policies? Your policies are where you show what is important to you as an organization. This is where you define your values, and you can emphasize the importance of diversity and inclusion. So you may want to have a DEIA policy, and that is where you look at how you define it for your organization. You look at what is the diversity of the population that you serve. Does your organization reflect that? And what are your goals? Your policy may lay out guidelines to increase diversity. Those may include things like addressing any limitations of your current board candidate pipeline, looking at your director nominee criteria. Maybe instead of using your own network, you hire an advisor to identify board members. You might want to expand your board positions to individuals who aren't necessarily in those C-suite positions. And finally, you might want to mentor women and minority individuals to develop them into board candidates. Having a policy on DEIA can also help you retain the diverse board members that you already have, because again, it emphasizes the importance of diversity. And you can also conduct trainings on diversity and inclusion topics to emphasize importance. And finally, you can evaluate your board performance on diversity and inclusion efforts. You might also want to have a non-discrimination policy, maybe possibly even an anti-harassment policy. Again, to emphasize importance. You want to have a whistleblower policy, and this is about accountability and making sure that any issues that are going on get reported. You might also want to have a code of conduct, and in setting that up, you're going to look at who does that apply to? Does it go all the way to the top? And does it also go all the way down to the bottom, even to the volunteers? And you might want to have it signed annually. Again, this emphasizes the importance of it, and it holds people accountable. Next, you may want to look at your employee handbook. And gender neutral language is important there as well. One thing that I've seen some employers do is they voluntarily permit employees to identify their preferred pronouns upon hire. So that's part of their new hire paperwork. It's a voluntary sheet of what is their preferred pronoun. I've seen some organizations have that as part of their signature line, their preferred pronoun. But again, if you're going through your handbook, you can just refer to employee or team member rather than he or she. You definitely want to have an anti-harassment policy, a non-discrimination policy, and an equal employment opportunity policy. And you want to make sure these policies cover LGBTQ employees. You can explicitly state that discrimination based on sexual orientation or gender identity is prohibited. You want to clearly state the mechanism for complaining or reporting discrimination. And that includes harassment and retaliation. And then you also want to train your managers. What should they do if they receive a complaint or report? You may want to have a DEIA policy that applies to employees. And I want to be clear here, we're not talking about affirmative action. Affirmative action is where you may have quotas that require an employer to hire a certain number of minority employees. This is generally only lawful for the government or certain federal contractors. It's generally unlawful for private employers, and sometimes that comes as a surprise. But Title VII, which prohibits discrimination, applies not just to minorities, but it applies to everyone. And so you have seen, there are cases out there, they're known as reverse discrimination cases, where, for example, a white male sues because an employer hired a minority employee based on affirmative action, and courts have held that that was actually unlawful, and the white male was successful in that lawsuit because the affirmative action program was unlawful under Title VII, even though the employer was trying to do a positive thing by increasing diversity in the workforce. So instead of affirmative action, what we're talking about is, again, addressing any limitations to your current employee pool, eliminating any barriers to diversity. And a policy can also help you create a culture of inclusivity. Again, this will help you retain the diverse employees that you already have. And you might want to also have an open door policy. This is the kind of policy that can foster trust between management and employees. You still have to investigate any complaints of discrimination that you receive. So it doesn't take the place of your anti-discrimination and harassment policies, but this is a broader policy, and it's intended to help your employees communicate with you, to help them feel respected and heard.
Elizabeth, we have a question about the handbooks. Do they apply to volunteers, or should there be a specific volunteer handbook?
That's a good question. I have drafted separate volunteer handbooks for some of our clients, just because there's a lot that goes into the employee handbook that is not going to apply to volunteers. Sometimes you can just do a standalone set of policies. Like, for example, you probably would want to give your volunteers the non-discrimination and the anti-harassment policies, but those can be kind of taken out of the employee handbook and given to them separately, because it could get confusing if you distribute an employee handbook to a volunteer. So what can you do to address these issues for your organization? And the answer is self-assessment or audit. You can review your governing documents and policies and identify that language of inclusion and exclusion. And as Clay was saying, it may not be something that you do immediately right off the bat, but certainly as you come through that cycle of reviewing those documents, that's one of the key things you want to be taking a look at. You can also engage a DEIA professional. This is a large and developing area of focus in the corporate world, and there are more and more professionals out there that are knowledgeable in this area, and they can help you facilitate a board and staff training on the topic. They can help you define what DEIA means to your organization and what it means in relation to the people that you serve. You just want to be looking at who is using your organization, and are you reflective of those people? And you want to document what you learn in your bylaws and your policies. And by doing that, you're going to memorialize it as institutional knowledge so that going forward, the next generation has those standards in place, and the next generation and the next generation. And it may be evolving, it may be changing as time passes, as everything does. But you want to start in a good place. You may want to update your board orientation with a DEIA segment, so that that becomes an important topic right off the bat. And then, of course, you want to check in periodically, because diversity is always going to be changing. The topics that are important in society are changing, and the diversity of your organization, the people in your organization are going to be changing. So that's something you just want to be looking at from time to time. If that is all I have, I'm happy to take any other questions.
Yeah, thank you all. I know we're a little bit over time, but we're happy to answer questions and hang out for a little bit longer if you'd like. I know we've got a couple comments. Debbie Nelson indicated that there are a number of DEIA consultants on the consultant collaborative at Together SC. That is absolutely true. I've worked with many of them, as has Elizabeth. It's one of the things that attracts us to this organization is that huge network that surrounds it. See here that we've started to see grant applications asking for the DEI policy. We can confirm that's true as well. We've got a lot of folks that have been asking that. We know that's getting submitted in grants. It's funny, we've actually flipped the lettering around. We're doing DEIA because that's what most people are used to. We call ours IDEA, so IDEA, and I think that's more schmaltz than anything, but I kind of like it. Let's see, can you elaborate a bit on accessibility for websites? What kinds of actions can we take to protect our organization from an ADA claim about website accessibility? And so we are seeing that. We started seeing that first with public institutions, universities, and the like, but it's beginning to spread out. The claims that we've seen are typically made to the Office of Civil Rights, and they're dealing with accessibility for folks with some type of visual impairment. Do you have kind of voiceover technology, things of that nature? What I would tell you with that is there are very good IT folks that can come in and actually do an ADA review of your site. And so if this is something that you're interested in, if you're serving people in your community that you know have visual impairment issues, you know, or otherwise, then I would definitely tell you to look out there for an IT consultant that focuses on this. You can find them. There are folks in the area. I don't know if we have them in the consultant collaborative. Maybe, Debbie, that's something we should note to consider growing in the future. But I would definitely refer you. There are IT folks that do this for a living specifically.
I don't really have a response right now, Clay, to that question. I mean, I don't know if Ben is aware of any that are doing that. We certainly do have IT folks in our consultant collab. And I'm assuming if they're, you know, up to speed in their field, they're very aware of these requirements. So they probably could help, but I don't have a specific recommendation. Do you, Ben?
I was going to also point out one of our nonprofit members, Able South Carolina, does from time to time help organizations and employers with accessibility audits and things like that. So some of their staff can certainly help point you in the right direction on having your website reviewed for those sorts of things.
There's a question about how prevalent these claims are, thinking about safety versus accident cost. What I'll tell you is we're seeing a trend line where we're seeing a lot more of this activity. You're probably not seeing it because in most cases they try to keep it very quiet and try to prevent any PR issue. And my experience is universally the nonprofits respond and they take corrective actions and they address it. And so a lot of these litigation, it isn't as if people are suing for money, so to speak, although you can recover attorney's fees and court costs. They're really suing to have corrective action taken, and that's what we're seeing. We've seen it obviously with websites, but we've seen it in lodging that certain nonprofits do. You know, was a bathroom accessible? We're seeing it even in gardens where was it wide enough for a wheelchair? We're seeing it in performance halls and theaters, things of that nature. And you've got to go through that analysis of, are you grandfathered in given the date of the site? But we're seeing a lot of this stuff, and there are actually people that we're aware of now that are actively going out into facilities and confirming whether or not they can get in. And you know, I think it's even more important for nonprofits. We exist off of this tax exemption. We exist to do public good. And I think it's incumbent on us to be thinking about these issues, because it's not as if we're serving, you know, 98% of the public or 90%, it's 100%. And to me, that's where this gets to be really critical. It's that public service mission, and are you really being aware of it? And having this conversation, I think, is a critical step in that regard. Well, thank y'all for your time this morning. You've got our contact info. If you want to give us a call or drop us a line, we're happy to keep talking with you about this subject matter. It's obviously become fairly important to us, even from our basic documents and templates perspective. I hope you enjoyed it. I hope y'all will join us again on September 21st for donor confidentiality, and November 2nd to talk about wealth transfer, endowments, things of that nature. Y'all have a great day.
Thank you so much, Clay and Elizabeth. One last thing I'll just make a note of, just so that it's on the audio recording, because I've seen it in the chat box, is that grant applications and funders are increasingly asking questions about board composition and staff composition, leadership composition. GuideStar and Candid are asking this as well in order for organizations to have the gold seal on GuideStar. We'll be announcing before long a partnership with GuideStar and Candid to help our nonprofit members meet those requests in order to increase the number of nonprofits that have that gold seal status on GuideStar. So look forward to more information about that coming soon. So thank you everyone for joining us today. We really appreciate it, and thank you, Clay and Elizabeth, for presenting this to us.